Sexual abuse in this situation, while it may have been a motivation for Eric and Lyle to do what they did, does not constitute self-defense.
After years of petitioning by the Menendez brothers, today District Attorney Nathan Hochman announcing his office does not support a new trial, but he left the door open for other motions by the defense.
The lengthy press conference today detailing the DA's decision. KCAL News reporter Jasmine Viel live in downtown LA with today's announcement. Jazz?
Yeah, so Juan, the LA County DA came to this conclusion that there was simply just not enough evidence or any new evidence. And this after he went through what he says was 50,000 pages of court proceedings. He spoke to law enforcement and even with the Menendez brothers' family members. LA County District Attorney Nathan Hochman posted this 16-minute video Friday titled "The Anatomy of the Menendez Case." This after he gave his reasoning as to why his office believes the court should deny the brothers' habeas corpus petition.
If you're asking me, was there evidence presented in the trial about it, there certainly was. If you're also asking me, has new additional evidence come out about that beyond the Andy Cano letter? There is none.
Hochman says the Menendez case is proceeding on 3 parallel tracks: the habeas petition, a petition for clemency from Governor Gavin Newsom, and resentencing. He responded only to the first after examining 2 new pieces of evidence at the center of that petition.
The habeas motion focuses on the evidence at trial.
One was an undated copy of a letter Eric Menendez says he wrote to his cousin Andy Cano 8 months before the murders about his father's alleged sexual abuse, and a declaration from a boy band member, Roy Rossello, claiming he was also abused by Jose Menendez.
But the standard to actually have a successful habeas petition requires that you meet all of the following requirements. You have to show that it's new evidence. You have to show that it's timely, that it was evidence that could not be discovered at the time of the trial. So the evidence, if in fact this is true of what Roy Rossello is saying, would not be admissible to show their state of mind in 1989.
The DA says the evidence does not meet the rigorous standards of a habeas corpus petition. Hochman says these claims have been repeatedly raised and rejected by every court that has heard them. Last month, Hochman met with the Menendez brothers' family members who've been advocating for their release. In a statement, the Justice for Eric and Lyle Coalition condemned his dismissal of the abuse evidence, writing, "He didn't listen to us. We are profoundly disappointed by his remarks in which he effectively tore up new evidence and discredited the trauma they experienced." They added, if he is truly committed to justice, he will follow the law and issue a resentencing recommendation that reflects Eric and Lyle's overwhelming rehabilitation.
What I said to the family is that I would listen to them.
Family members have said the brothers, who were convicted in 1996 of first-degree murder for killing their parents, faced abuse, trauma, and have demonstrated rehabilitation over the last 35 years. Hochman says he will deal with the resentencing issue in the coming weeks that considers those rehabilitation factors. He also encouraged the governor to do the research.
The clemency power he has is vast. It's unilateral. He can do it literally today.
But you know what? The court can move forward with that petition regardless of the DA's position that he took today. As for that much anticipated resentencing hearing that was delayed by the LA wildfires for the Menendez brothers, that is now slated to take place on March 20th. And coming up on KCAL News at 5, we are expecting to hear also from their attorney, the Menendez brothers attorney, Mark Garagos. Live here in downtown LA, Jasmine Viel, KCAL News.
All right, Jasmine, thanks for the update.